But we tasting things like that, but she hadn't gone to the night. So, so it's good. I'm going to have a spread. I think I'm all right. So we did the reading school. The one just she didn't have me this morning, so yeah, just let us know. No, we're all here. Yeah, like oh yes, everyone's yes. So she she's there. And you can. Yeah, all right, well, we might just start getting ready. Tell me if the online people can hear me, hopefully. All right, we might make a start. Thank you, everyone. We'd just like to start today by acknowledging the traditional owners on the land on which we work and pay respect to elders past, present and emerging. We acknowledge the continued deep spiritual attachment and relationship of Aboriginal and Torres Strait Islander people to this country, and we commit ourselves to the ongoing journey of reconciliation. I'd also like to take this opportunity to recognise the strength and resilience of adults, children and young people who have experiences of domestic, family and sexual violence, and acknowledge that it is essential that the responses are informed by their expert knowledge and advocacy. We pay respect to those who did not survive and acknowledge friends and family members who have lost loved ones to this preventable and far-reaching issue. Good afternoon, everyone, and hopefully everyone online can hear us. Yes, yeah, sorry. Due to the hybrid nature of this event today, the online attendees will only be able to see the slides, but you should be able to hear us. We have someone monitoring the chat, so if at any time you can't, please yell out in caps. And we'll intervene. It's really great to have you all here today. My name's Jess and I'm the Manager for Sexual Violence at the Centre for Women's Safety and Wellbeing. We're the peak body for all the family and domestic violence services, the community-based women's health centres and the sexual assault services. This workshop is being held in partnership with the Sexual Assault Legal Service, WA, SALSWA, which is a partnership with Women's Legal Service WA, Aboriginal Family Legal Services and RUA to deliver statewide legal services for victims and survivors of sexual violence in Western Australia. Before I go any further, there's just a few housekeeping issues. In case of an emergency, there is a fire exit in this room. There is also a fire exit just out in the foyer near the lifts. Toilets are back in the foyer by the lifts. We will have a short break, as you can see on today's agenda, so help yourself to refreshments during that time. And just a note that this workshop is being recorded and will be made available online afterwards. As I said before, for the people online, the chat is being monitored, so please put any questions or comments in that chat. This workshop has basically come about due to the kind of increasing volume of requests to services for sensitive records and counselling notes. The requests that services are receiving are coming from a variety of places, including through civil courts like VROs and the Family Court, and criminal trials. Given the variety of places that the requests are coming from, there's been quite a lot of confusion, I think, for frontline services and how best to respond to these at times. And critically, some of the issues that have been raised with us as the P have included subpoenas through the criminal trial system, police gathering the records as part of early evidence collection, records being requested through avenues like APRA, and records being summoned through the civil law system, as I mentioned before. Today, we'll be focusing mostly on the criminal matters, and particularly around Section 19C of the Evidence Act, which creates certain protections around sexual assault counselling records. There are some changes to the Family Law Act that are due to come into effect later in the year. So we'll do a kind of workshop later on in the year that focuses more on those kind of requests, that avenue, once those changes come into effect. I think it's also important to clarify that the information given today doesn't substitute for legal advice for any cases you might be dealing with at the moment. It's about information sharing. So for the agenda for today, which is on the screen, we've just got a bit of a, most of the focus will be today about what is a protected communication, and kind of go into the detail about what those provisions currently are. Then we have WA Police here to join us today to give a bit of a WA Police perspective. And then we'll have a short break. We've got the Office for the Commissioner of Crime, Victims of Crime here today, who will give a little perspective as well. And then we'll go into some case studies. We've set quite a lot of time aside for questions at the end. So if questions come up during the workshop that are really pertinent, we're happy to kind of answer them as we go, but also happy for you to just kind of save them for the end, where we've got quite a lot of time set aside. Finally, before I kind of kick off, I just want to note that we've got the Sexual Assault Legal Service anniversary event that follows this one tonight. So you're most welcome to stay around after the workshop for that event to hear the panel, and I hear there's some drinks. All right, so now we're very fortunate today to have Liam Nichols, who's a private barrister from Francis Burt Chambers, who's going to present on the protected communications provisions. Liam has worked with the Sexual Assault Legal Service WA on a few matters quite relevant to the topic today. And he has very kindly given up quite a lot of time and his expertise for this workshop today, and we're very thankful for that. And so with that, I'll hand over to Liam.
Thank you, Jess. So just by way of overview, so today I'll just be giving some general information about these protected communications provisions. As Jess said, it's not going to be legal advice, but it will be hopefully sufficient to give you a bit of information about the ins and outs of these protections, and most importantly, to let you know they are there and they can be very powerful. The structure of my presentation, which will run for about 45 minutes, is first of all to give you a bit of context as to confidentiality in litigation and criminal proceedings and the use of compulsive court processes to access confidential information generally. But then also, what is the protected communications regime? Why was it introduced? Which types of communications are covered and how are they protected? And then what to do if you receive a summons that appears to require you to produce to the court protected communications. And then hopefully, if we have enough time, just to go through a few other safeguards that where the protected communications regime might not apply, what other options might you have available to deal with the production of sensitive materials. Now, I am conscious that we have a variety of different people attending today and online as well, that you have different expertise, different professions, different occupations. So I have tried to put in different bits and pieces for different lines of work that you might be doing. But as a result, I think some of the counsellors in the room might find some of the more technical legal aspects a bit boring. Some of the lawyers in the room might find the other aspects a bit boring. But I figure if on average you're all bored, then I've probably hit the mark. So first of all, and this just to set the scene as to how confidentiality is ordinarily dealt with in litigation. Now, I think you're all, of course, like everyone, accustomed to dealing with confidential information personally. So your own medical records, your bank records, your employment records, they're all confidential. And then, of course, in your work, you're also accustomed to dealing with confidential information. Maybe it's legal advice, maybe it's private counselling notes, which is something we'll be speaking about a lot today. And the law has recognised for a long time the importance of maintaining confidentiality, but it's not absolute, because in litigation and court processes, confidentiality often has to give way to other interests which are often considered more important. And so, say in a criminal case, it might often be considered more important that the accused has a fair trial, and therefore has access to materials that might otherwise be confidential. And then even in civil litigation, the purpose or objective of trying to seek the truth and establish some level of truth in litigation might mean that the parties are entitled to see materials that otherwise no one would ever see. So it's not unusual to require people to produce confidential information in court proceedings. And I thought I'd just mention briefly the process that's involved in applying and obtaining a subpoena or a summons, just to show you just how easy it is to obtain these sorts of things in court proceedings. And first of all, the term subpoena or summons is often used interchangeably, and some courts will use the term summons, others will say subpoena, some will use it just interchangeably. So where you hear those terms, all its meaning is it's some sort of order from the court requiring you to either turn up and give evidence orally as a witness, or produce documents or records to the court, or sometimes do both things. Now, to obtain a subpoena or summons, I mean, once you're involved in a court proceeding as a party, so for example, if I commenced a civil case against someone, or I was being prosecuted for something, and so therefore there's some sort of court case on foot, it is extremely simple and straightforward for me to go and get a summons or subpoena from a court. So it's subject to some exceptions, including the protected communications regime. It could be as simple as me just typing up the sorts of records I want in a form, sending it off to the court. There's really no level of scrutiny that is applied, and I get back a court order requiring that third party to produce materials. And so I go serve it on the third party, and they have to comply with it because it's a court order. So it's not like orders you might see coming out of a trial or a contested hearing where a judge has sat down and heard evidence and made a determination, and there's an order that comes out of it. In a lot of cases, there hasn't really been any scrutiny that's applied by the court in making the subpoena or summons. And that's no criticism of the courts either, because when they receive these applications, they have very little information about the issues in the case. And so it's really not for the court registrar or anyone behind the scenes at the court to make a determination as to what's relevant or anything along those lines. Just as a matter of really practicality, they have to they do routinely make these orders without applying sort of any rigor. That's a general proposition. There are exceptions, including the protected communications regime. I think another important thing to be aware of if you are dealing with subpoenas and summonses is that the order is for you to produce the material to the court. I've seen a lot of cases where, particularly if it's a self-represented litigant that's obtained the summons, they'll be on the phone to the service or the organisation saying, there's the order, you need to give them to me. That's not the case. The requirement is that you produce it to the court. So the protected communications regime is found in sections 19A to 19M of the Evidence Act 1906, which is WA state legislation. And in the most general terms, it's about criminal cases. So it's not about civil at all. It's about criminal prosecutions. And it reverses this default position I was saying before, where anyone can just go and get a summons and require third parties to produce records. The idea is that court intervention is required first. So the person seeking this material needs to satisfy the court that they should be given the ability to access this material. And so it's a significant hurdle to jump over for the applicant, and it completely changes the default position that would ordinarily apply. And it is just about sex assault counselling communications. So it's not about other types of counselling that might go on relating to other other things that have happened to victim survivors. Again, at a very high level, and we'll go into a bit more detail in a moment, it's a two-stage process as far as the applicant is concerned. They have to first put forward some material to the court, trying to convince the court there's a prima facie legitimate forensic purpose. So, is there a real reason why we need this material used in the case? And so if the court looks at that and says, yes, I think you've sort of met that minimum threshold to show that this might be something that you need in the case and there's a legitimate forensic purpose for using it, then there's what I'd call a full-blown hearing where the parties attend and even the complainant has the ability to attend, as well as others, to argue about whether permission should be given by the court to allow the documents to be disclosed or used in the court proceedings. And it applies to written and oral evidence. So often you'll probably encounter requests for documentary records, but it could also come up if you've been asked to provide evidence orally, and that might touch on counselling communications you've had. The reason for introducing the regime is probably obvious to a lot of you, but going back to 2004 and prior to that, that default position I was explaining before of parties, including the accused, just being able to issue summonses and obtain records, that was also the case for sensitive counselling communications relating to sex assault. So in 2004, the then State Attorney General, the Hon. Jim McGuinty MLA, introduced a bill into the state parliament which contained a whole suite of reforms relevant to sex abuse and child sexual abuse cases, which had a lot of big ticket items in the reform. So there was joinder of criminal cases, meaning you could try simultaneously multiple cases against the same accused more easily. Propensity and relationship evidence reforms, which allow you to rely on, for example, the accused propensity to have a sexual interest in a child and act on that interest, which is an incredibly powerful tool in prosecuting child sexual abuse cases. Visual recordings of interviews with child complainants, special witness status, and then protected communications. So it was a significant reform at the time and introduced a lot of things that are still used every day today. The Attorney General, when he introduced the bill into Parliament and in his second reading speech, quoted at length from correspondence he received from the WA Sexual Assault Resource Centre in support of these protected communications reforms. And I'll just read from some of that correspondence. So the correspondence said, and I quote, "The counselling relationship is one which is necessarily based on privacy and trust. Confidentiality is an essential ingredient in maintaining levels of trust. For victims of sexual assault to have this trust broken by the public production of their counselling notes only adds to the process of victimisation and trauma. And in addition to this, if the confidential communications conveyed during the counselling relationship are disclosed to the defence, the complainant's difficult recovery process may be jeopardised and the benefits and gains already made by the client can be instantly lost. If victims of sexual assault are aware that counsellors cannot guarantee confidentiality, they may reject counsellors as a source of support. Without this support, victims may fail to report instances of sexual assault to the police. A therapeutic counselling relationship is essential to assist in the recovery process undertaken by victims of sexual assault and to reduce the impact of the trauma and its consequences. And finally, victims of sexual offences are often further psychologically traumatised by the knowledge that the alleged offender may find out about the effects of the assault on them or other personal information, such as addresses and medical sexual histories. The Attorney General, in his second reading speech, also referred to research coming from Canada suggesting that 17% of women surveyed identified the fear of record disclosure as a reason for not reporting sexual assault to the authorities, making it, according to that study, the second most significant factor for not reporting. So that bill passed Parliament in 2004, and then by 1 January 2005, it had come into operation. So it's now, this regime has been around for 20 years. And I'll now move to what communications are covered. Now, one thing that will be apparent to you when you look at these provisions, and hopefully if you haven't already, you will look at them, is there's a number of defined terms that are potentially quite complicated, depending on the types of communications you're dealing with. And you'll see most of them are set out in section 19, capital A. And I'll go through those in a moment. But for those of you lucky enough not to regularly read legislation, a defined term is really an expression that's used by parliamentary drafters as a shorthand, sometimes to refer to things that go beyond, the ordinary meaning of a word. But other times it simply largely accords with the ordinary meaning of a term. But so it would be within the realms of possibility that you could be reading a statute and it says, well, for the purposes of this statute, dog also includes cat. And then so every time you read dog, you have to read it as also including cat. And you'll see here that some of the terms used don't necessarily accord with the ordinary meaning, and some of them go beyond what the ordinary meaning of the word is. To make things a bit more confusing, as you read these defined terms, in explaining what's captured in a defined term, it refers to other defined terms. And so you need to trace them all through and read them together in order to fully understand the scope of these provisions. So the next few slides, I've just reproduced in full some of these defined terms, and apologies in advance if it gets a bit dry, but they're critical in understanding whether a communication will be captured by these provisions or not. So the first is that a protected communication means a counselling communication made by, to, or about a complainant, and includes a counselling communication made before the commission or alleged commission of sexual assault, and also a counselling communication not made in connection with sexual assault or alleged sexual assault, or any condition arising from sexual assault or alleged sexual assault. Now, the terms I've bolded there, counselling communication, is to show that, well, yes, there's a separate defined term to then tell us what is a counselling communication. And here in this next slide, the expressions that I put in blue font are important terms, but they're not defined in the legislation. So they're things that may well be open to argument and interpretation, but you won't find the answer in the terms of the statute. But I just wanted to flag those to make you aware of them. But the other terms that are in bold are things that are defined in the terms of the statute. So I won't go through each of these limbs of the definition, but the first one is probably the most important to understand for now, which is that a counselling communication means a communication made in confidence by a person upon or in respect of whom sexual assault was committed or is alleged to have been committed. And so that person, for the purposes of these provisions, is called the complainant. And that communication is made to another person. And for the purposes of these provisions, that person's called the counsellor. And that person is counselling the complainant in relation to any harm the complainant may have suffered. So then what does counsel mean? And so here's a definition which might not necessarily accord with your ordinary definition of what it means to counsel someone. And in fact, it may be broader than what maybe I'd ordinarily describe as counselling and seeing a counsellor. So a person counsels another person if the person has undertaken training or study or has experience that is relevant to the process of counselling persons who have suffered harm, and we'll get to the meaning of harm in a moment, and the person listens to and gives verbal or other support or encouragement to the other person, or advises, gives therapy to, or treats the other person, whether or not for fee or reward. And so there was one case that was decided where the child had spoken to a teacher at the school who had undertaken a short course in counselling, and part of her job at the school was to provide pastoral care to students. And so the court was satisfied in that case that that ticked the box for a counsellor who was counselling this child complainant, even though perhaps some people wouldn't ordinarily say, oh, well, that was a person who was counselling. They might say, well, that was just a teacher speaking to a student. So it's always important to, when we're looking at these types of things, we're not assessing it against the ordinary meaning of counselling. It's assessing it against, well, do we satisfy the conditions in the legislation? And then harm, obviously a very common form of harm would be physical bodily harm or emotional or psychological harm. But this inclusive definition. And inclusive, if you ever see the word includes in legislation, it's a flag that means, well, this is not exhaustive. So it might be other things, but it at least includes these things. So it tells us that it includes actual physical bodily harm, but it's also financial loss. It's also stress or shock. It's also damage to reputation or emotional or psychological harm, such as shame, humiliation, and fear. And the term harm appears in several places in these provisions. Now, in some cases, it's probably going to be quite straightforward that these conditions are satisfied, because if it's to use just a very basic example, if someone has experienced sexual assault and goes and sees a psychologist in relation to the psychological harm they've suffered as a result, that would most likely very clearly satisfy the conditions that we've just gone through. But the cases have shown us that it's not always as straightforward as that, because, for example, issues have arisen in previous cases where there's questions about, well, was that communication really in confidence? Because the person had said, the counsellor had said, I'm going to need to disclose this to other people because I'm a mandatory reporter. So the question was, well, is that really in confidence if the complainant understood that the information was going to be given to others? Another question, like with the school teacher example, has the counsellor undertaken relevant training or study, or do they have relevant experience that would satisfy that condition? And then also, was the complainant being counselled for harm, or was there some other reason why they were speaking to the counsellor? And that can come up as well, where they might be speaking to an appropriately qualified person, but we need to understand why they're speaking to that person. So it's potentially quite complicated to even figure out at this first step whether something's protected or not. The next thing to really understand is, well, let's assume it is a protected communication, or at least it appears to be. Then what is the effect of this regime? How are they protected? The starting point is quite simple, which is that if it's a protected communication, a person cannot disclose it, they can't use it in any criminal proceeding except with the leave of the court. And leave, which I might mention in other contexts, just means the permission of the court. And so without the court giving leave, that evidence is inadmissible, meaning, well, not only can't you get a subpoena or summons to obtain it, but also if somehow the party or the accused, for example, somehow had access to it, it's still inadmissible. They can't use it even if they had it. So that's a significant starting point, which is completely different to the default position I mentioned earlier that normally applies with subpoenas and summonses. And importantly, if a subpoena purports to obtain this type of material and leave hasn't been obtained from the court, then the subpoena is of no effect. So these are very powerful provisions if the material is in fact protected communications. And I should say at the outset, all of these protections are always subject to the consent of the complainant. As long as they're an adult, child complainant can't consent to the use of protected communications. But certainly an adult complainant can. And there may be reasons why they actually want to consent, because they might not want to consent to the accused using material against them, but they may well want to consent to the state prosecutor using material to advance the prosecution. So that's always the prerogative of the complainant, that they can consent if they want to. There is a district court circular to practitioners, which, although that's directed at legal practitioners, I think it is helpful to understand this circular and be aware of it if you're the person who's receiving a summons, because that makes it very clear to legal practitioners about the effect of this protected communications regime, and explains that the court will apply scrutiny to requests for subpoenas or summonses that appear to require the production of protected communications. And the registrar of the district court will refuse to grant a summons if it appears that it's going to require the production of protected communications and leave hasn't been obtained, or presumably the complainant hasn't consented. So they will refuse the issue of a summons. That's obviously not foolproof, because it won't always be apparent from the terms of an application for a subpoena or summons that it is capturing or potentially capturing a protected communication. And the suggestion in this circular is that, well, if the practitioner or the party hasn't obtained leave or doesn't have the right to obtain this material, they really ought to be including wording in the terms of the subpoena or summons to exclude protected communications. And there's specific wording there they should use to say, they seek whatever document. So maybe it's, the patient's medical file at whatever medical facility, except for any document, recording, or evidence which is a protected communication as defined in Section 19A and Section 19B of the Evidence Act. And they're required to then attach those provisions to the summons so the person receiving it can see them. Now, if the party, in fact, does want to access protected communications and use them in the case, there's this two-step process. They bring forward an application. They need to show the court that they at least have a prima facie, so on its face, there's a reasonable argument that there is a legitimate forensic purpose. And in a moment, I'll explain a bit more about what a legitimate forensic purpose is. And once they get through that initial threshold, and if the court agrees that there appears to be a legitimate forensic purpose, there's then a hearing where the court then decides whether leave should be given. And in doing that, they have to consider whether the release and use of this information is in the public interest. And we'll get to the public interest test in a moment. So the legitimate forensic purpose, this is it's an important term. It's not defined in the legislation, but it gets its meaning from case law or common law. And it effectively means where it's on the cards is the expression they use, on the cards in the sense that there's a reasonable possibility that the material may materially assist in the applicant's case. So it's not enough to just show, oh, well, this is sort of relevant to my prosecution. The person needs to show it might materially assist their defence. And so it's also not enough that you might have heard the term, fishing expedition. So it's not enough that the person's just casting the net out and hoping they can gather some material that might assist them. It needs to be more than that. They need to show there's a legitimate forensic purpose. And some examples of where there might be a legitimate forensic purpose is where the accused is establishing that the complainant has made a prior inconsistent statement. So they've said something that's opposite to what they're saying now or inconsistent. That might be a reason the accused wants a document, but also the state, the prosecution might want to use the document to show evidence of recent complaint that's consistent with the allegations that are made or the distress condition of the complainant. So those are the types of reasons why the court, if satisfied appropriately, might allow the use of the materials. The process to have the hearing, I won't go through in detail, but it does effectively allow the complainant a right to make submissions to the court as to whether the materials should be disclosed. It also allows the organisation or the counsellor to participate in that process. So it's affording really procedural fairness is the legal term, but allowing everyone who should have a say to have a say if they want to. Although there's no obligation for them to participate in the hearing. The leave question, as I said, will ultimately determine on whether the disclosure is in the public interest. There's various specific public interest considerations the court has to consider. I've summarised them on the slide, but in short, these considerations are important. And, is it necessary to have these materials for the accused to make a full defence of the charge against them? Does the material have substantial probative value? And that's a particular legal expression, which is getting at the point that, is this some peripheral matter that really doesn't go to the heart of the case, or is this actually something of substance? The provisions expressly acknowledge the public interest in receiving effective counselling that has to be taken into account, and the public interest in ensuring adequate record keeping, which I think is an important one, because of course, I think the worry of the legislators would have been, well, if everyone can access all these counselling records, will that have the consequence of counsellors not writing anything down out of fear that they have to hand their notes over? So that's acknowledged as a very important public interest consideration. And finally, the likelihood of harm caused by releasing and using this information and the nature and extent of the harm is, and the court can really otherwise take into account any matter that it considers relevant to the public interest test. So that, in a very shorthand way, are the provisions and the effect of the provisions. I will now just briefly touch on a few tips where you're the recipient of a summons and it appears that it might be asking you to produce documents or records or things relevant to a protected communication. The first tip would be to seek legal advice, because this is potentially an incredibly complicated area of law. And you can even see that in the way cases have been decided. The state will take one view, the accused takes another view, the judge has another view. Then you have another case where the next judge took a different view to that judge. And so there's not necessarily consensus as to the effect of all these provisions. And I do think, given how fraught it is to say whether or not it's definitely a protected communication or not, and given how often we can see in the decided cases, one person has asserted that it's a protected communication only for the court to say no, this is a very difficult and tricky area to navigate without the assistance of lawyers. And as the cases show, even with the assistance of lawyers, that it's still difficult. These are very tricky provisions. So the next step would be to read the terms of the summons. If it has an exclusion in there, then that should give you some comfort that they're not at all trying to get protected communications, but they might be trying to get other things in your files, which might be completely in accordance with the protected communications regime, as in the person seeking the order was conscious that they can't access it, so they've excluded it from the scope of the summons. However, if it does appear to capture protected communications and you're not aware whether the complainant has consented or the court has given leave, you probably ought to find out. So certainly if it was me involved, I would be conferring with the lawyer for the party who has sought the materials. Alternatively, if you're not comfortable speaking to the lawyer representing that party, you could contact the court directly and ask whether they can confirm if leave has been given. Because, of course, if leave has been given, you may not have any option other than to just produce what's been required of you. So if the person who's seeking this material has, and sorry, I should just repeat the question. The question was who gives the leave? And so if the party was wanting to obtain protected communications and then went through the process with the court and got leave of the court to obtain the materials, then it may be that this summons just has to be complied with and you have to hand over the protected communications. And this might be an obvious point, but it bears emphasising that it is a court order. So I've worked with clients before who've said, well, I'm just not prepared to hand over these records. They're confidential, they're sensitive or whatever. But unless there's a legal basis to object to that, and hopefully a lawyer is assisting you with that, it is a court order. It doesn't matter that it was the accused that went and got the order, or a perpetrator in a violence restraining order application got the order. It is a court order. So it's and some people, I think, certainly clients I've worked with find it very difficult to stomach that they're having to comply with this thing against, knowing that they're producing this information that the accused or a perpetrator might have access to. But at the end of the day, it is a court order. You have to comply with it unless there's some reason that we can go ahead and challenge the issuing of it. And then finally, see point one. So legal advice is really, if there's one takeaway from today, it's get legal advice if you think there's at all an argument here that the materials that they're trying to obtain are protected communications and there might be a reason to resist producing them. And just the final slide, and it goes beyond the, oh, sorry. And you're saying because it is a case that doesn't relate to, well, what does the case relate to in that sort of scenario? Right. So, well, typically, so family court is civil proceedings. So this protected communications regime is for criminal proceedings only. there, and I don't practice in family law, so I certainly don't have the expertise to even give general information about the protections that might exist for family court proceedings. Although, as Jess mentioned in the introductory comments, there are changes being introduced into the Commonwealth the Federal Family Law Act, which will provide a level or at least an option to protect communications, including, as I understand it, in that context. But these safeguards that I'm about to go through may be applicable and relevant in family court civil proceedings. But again, yeah, and certainly as a general proposition, that's exactly how case law can be utilised, that it can transfer across different subject matters and different types of legal cases. For this type of situation where the legislation is highly prescriptive and it, as a threshold matter, says this is only for criminal cases, there's really no ability for a civil court to say, oh, well, we're just going to apply these provisions. So that would be an error for a court to do that. But as I'll go through in a moment, there are other things civil courts can rely on, which aren't quite as powerful as the protected communications regime for criminal cases, but they certainly can be helpful in certain circumstances. The first is that there's a series of provisions that follow the protected communications provisions and 19A, etc., that are found in sections 20A, capital A, to 20 capital F of the Evidence Act. And that sets out a mutually exclusive regime to the protected communications regime. And so that means if the protected communications regime doesn't apply, it may be that the communications are captured by this other regime. One of the main things to understand about this other regime is that its starting point is not like protected comms, where the accused or whoever has to go and satisfy the court that they should be able to use the material. Instead, the ordinary position applies, where anyone can try to access whatever information they want with a subpoena or summons. But these provisions, 20A to 20F, allow a party and other people to apply to stop the use of that. So it relies on the person trying to block it rather than having a starting point where the accused or the party to the case has to obtain leave, if that makes sense. So it's a different starting point. Now, that could be utilised in a family court case. It could also be utilised in other civil cases. But it would be contingent on, say, you as the person receiving the subpoena to go and apply to the court to try to block it, or it might be reliant on the other party to the case applying to the court to block it, or it could rely on the person who has provided the information to you to go away and try to block it with the court. And those provisions, from what I can tell, have been used very rarely, and I'm not even sure how well understood they are or well known about amongst the legal profession, but it's potentially a very powerful tool in stopping the use of protected confidences that, while they don't fall within this earlier regime I was talking about, they may well still be subject to protection under these provisions, as long as someone's actually putting forward an application. The court, as with the protected communications regime, the court is also able to act on its own initiative, is the expression. So even without an application, a court could, in theory, say, well, this appears to be something that someone may want to restrict using these provisions, and I'll hear an application about that accordingly. The other things I've identified there are really, from the common law, different grounds that you might resist compliance with a subpoena or summons and effectively have it set aside or cancelled. And so, and you would certainly need the assistance of a lawyer in making out these sorts of grounds, but there are limits really to what subpoenas and summonses can do. And so if someone is going on a fishing expedition and trying to just speculate as to whether materials might be relevant to the case, that might provide a basis in common law to go forward to the court and say, we want this cancelled. And that's regardless of the type of communication. You know, that could be a bank record that someone's just sent off subpoenas to every bank just fishing for information. that might provide the banks with a sufficient basis to resist and apply to cancel the summons. Is it oppressive, which is a legal expression that means it's too burdensome for someone to comply with? So maybe the person's asked for 30 years of records, and perhaps that's too oppressive to comply with, and it needs to be narrowed. Phishing I've mentioned, but also, and these are generally just forms of abuse of process is the legal expression, but there are other forms of abuse. So is someone using this summons or subpoena for an ulterior purpose? Are they actually trying to get the material so they can advance a different case? Because if so, that's an inappropriate use of the subpoena or summons process. And so these are all very complicated concepts and often very complicated to try and advance a case on and convince the court that they should cancel the summons or subpoena. But I wanted to let you know that there are these other options that may be available, even if your particular materials don't fall within the protected communications regime. And then finally, family counselling communications, again, with the caveat, I don't practice in family law, but there are already protections within the family court system about certain types of counselling communications. Again, it's highly prescriptive as to whether the boxes will be ticked in a particular case, but they generally protect family counselling communications. And the new changes that are coming in, which I think is potentially as soon as June, and again, this will be in relation to family court proceedings, but those provisions appear to draw on some of these concepts we've been talking about confidential communications. As I understand it, it relates to with health services, specialist family violence services, specialist sexual violence services. And on my quick reading of it, it seems like rather than completely blocking someone from having access unless they get the permission of the court, it probably is incumbent on the people who are wanting to block the access to bring forward an application and stop the production or use of those materials. But any family lawyers in the room can probably elaborate on that. Now, that's it from me. I think, if there are any questions, we have ample time at the end of the workshop to go through anything that's arisen. Thank you.
Thanks, Liam. I'm just going to try one thing because the slides were not moving with the people online. Do you want to try to take control, Anna? It's moving now. Right. Well, our next speaker doesn't have slides, so we're staying on her name, which works well for the purposes of the slides not moving for our online attendees. Sorry, everyone online. We are recording this and we will send the slides and everything around afterwards. So apologies for the technology breakdown. There was bound to be one. Thank you, Liam, for your wonderful comprehensive overview. It's now my great pleasure to introduce Detective Inspector Nat Jackson from WA Police to kind of cover off on some of the WA Police perspectives.
Thank you. And as said, I don't have any slides. I'd like to say it's because I've been nice to those online. It's just technology and I are not the greatest of friends. So I just find it easier if I just stand up and talk about our side of protected communications. So as everybody would know, WA Police, we don't tend to issue subpoenas or summons. Ours comes under the Criminal Investigation Act of 2006, and you get an order to produce, which gives you 7 days typically. We can give you as much time as we like, but most investigators will aim for about a 7-day turnaround to provide to the investigating officer what is actually protected communications. So what I'm here to discuss is we do broadcast to WA Police to advise people that they should not be asking for protected communications. That advice comes from the DPP quite often. So the requests should have lessened, and if they haven't, please let me know either in question time or just throw something from the audience. Reason being is the section that covers the production of the order to produce, it's signed by a JP. So it's not anything that the courts actually had a formal opinion on or been subject to what Liam's explained. So our order to producers have to be very specific. I think our application for those comes under Section 53 of the Criminal Investigation Act, and it has to be specific. It has to give exactly what we're after and timeframes. What you'll find is probably a lot of our order to producers are counselling notes in relation to, Jane Smith, with no dates, no times, not what it relates to. That really doesn't fit within the order to produce and what it's there for. So the order to produce is for us to get business records, which will assist in an investigation. When I do talk to some of my investigators, so for those who don't know me, Sex Assault Squad and Child Assessment Interview Team are the areas that I oversee for the Sex Crime Division. They talk about we get the counselling notes so that we can do a comprehensive early complaint statement. So, the counsellor is probably most of the time the first person somebody's told about a sexual assault. We don't need the notes to do an early complaint statement. The counsellor can read those, make a determination whether or not they wish to give us a statement, because, again, what's been spoken to them is protected communication. So it's their decision whether or not they give us a statement, and we don't need those notes in which to formulate it. That comes from our witness. I get quite a lot of phone calls from people who've had order to producers served last year, and I became a bit of a contact point. What I say to people is Section 55, pretty sure it's subsection 2, protects you. So what you'll get from some overkeen investigators is under Section 55, if you fail to produce it, you can be charged. Subsection 2 talks about without reasonable excuse. If you believe it's protected communications, seek legal advice. You have the ability to not produce them at that point in time under legal advice, and it can go to court, and the court can make the determination whether or not they should be given to WA Police. So I say it's easy because obviously we read the legislation, we get schooled on it, we get advice on it, we have our in-house solicitors to provide advice. It's very difficult when you've got a piece of paper from police saying you will produce this within 7 days to turn around and say, no, thank you. Because most people go, I've just been told I can be charged. Now, to me, that's incomprehensible. We're all working together for our victim survivors. So I think the number one thing we should do is at least be cordial to each other during quite a tough process. If that happens, you have every right to go back to the investigating officer or ask to speak to a supervisor or their district office. So their district office is someone like myself. So then you can say, I believe that this breaches legislation. I believe this request is not legitimate. And we have the ability to look at it and provide some advice as to whether or not it should be given. I had one recently where it was as a result of a child physical abuse, and we asked for certain records. We had to narrow it down because it sort of went from, 400 years worth of records. So we narrowed it to the time frame we were after, but we gave the presumption of sensitive. So when we disclose our material to the prosecutors and defence, we can mark it as sensitive, which means it's a court determination as to whether or not those records are handed over. So we have that ability to have them, not be able to utilise them. As it's been explained, we can't use those, no side can use those. But if it's something we need to maybe secure, we do have that ability. But what I say is if you're unsure, you can go to anybody else in WA Police. You can go up the chain of command. Please don't feel bad doing it. Please don't think the investigating officer is going to get a tough time. They might, but that possibly. We shouldn't be asking for them because ultimately at the end of the day, we are the ones as well that direct our victim survivors to counsellors. So we should not be directing them somewhere to then obtain records which breaches every confidentiality those victim survivors have. We all know we all work in the area. For them to trust anybody to tell their story is a massive, significant, life-changing event for them, and we should not be doing anything which pushes them away from that counselling and that support service, which gets them through the worst part of their life and then gets them to the court process, which starts the next period where they require that assistance. Everything that we do under the Criminal Investigation Act of 2006 seeps into the Evidence Act as well. That's the overriding act for us, and I'm sure there's some very good lawyers here who will throw something at me if I'm wrong. But the Evidence Act override, like that is pretty much once it gets to court, that is the rules of the game type of thing. So if we're not specific, and that's for any order to produce you may get from WA Police, it might not just be for counselling records. If we give you something that is not specific and it just says records of such and such, you have the right to go, what dates are you asking for? You've got, you know, we get it signed off for a 7-day period. When I do mine, I tend to give 28 days because I think that's a little bit nicer. But sometimes the investigation is urgent, so 7 days is our turnaround. So if you do get something that you're not sure of, legal advice is the best I can give you, because I'm definitely not a lawyer. There's a reason I'm a police officer. So I can only give you from our side at sex crimes, bearing in mind not every person that gives you an order to produce is going to be from my area of the police. There's local detectives, regional detectives that all work with sexual assault survivors. So not all of them come through our division where they get told this upon basically starting what they can and can't do. So bear in mind, all of us are human, and we will ask you probably for something that we shouldn't be asking you for in some stage. If you have any major dramas, if somebody does threaten to arrest you, please, Section 55 gives you some protection, seek legal advice and go back through the channel, because I don't expect we should be charging anybody who doesn't give us protected communication, because we shouldn't be asking for them. Pretty much close to 10 minutes, but not quite.
Does anyone want to ask any questions while that's up? I have one online, Anna. It's related to police.
And that people online can't hear the question,
Okay.
unless I'm standing
Yeah.
nice and close to the
Fire away.
microphone. So, and you've definitely spoke about this, but just to make sure that everyone's clear. So, if a client file, notes are provided to DPP or police as part of an investigation, what happens if the accused later FOIs the files concerning that investigation?
So from the police side, obviously I can't talk to the DPP side. From the police side, under FOI, it goes through a separate section of WA Police. So they ask for the freedom of information. If we've marked it as sensitive and can only be released by a court, they should not be given during freedom of information request. But I say shouldn't. I can't guarantee, because it shouldn't happen. Once the court case is over, that may be different if a court's then given leave for the accused or prosecutor, or the defence or prosecutor to use it, then it would be subject, FOI would attach, and we'd be able to give those documents out if the court has allowed them to be used in the court process.
Thank you. Now we're just going to take a quick 10-minute break before we kick off into case studies and some other things. So help yourself to some tea and coffee, and the toilets are just outside. And we'll meet you back in at 2:10.
We have one recently. You know, yeah. But they'll think they'll think to them as well. Sometimes the wild is better. Harder to cop up with so is to me I go to see inside as I go the psychology, the counselling, I sit there and I go, thank you. Other stuff. Yes, but she's like, so she said, yeah. Well, basically, it's don't be kind to appreciate. Yeah.
And the other one's share point, you know. So I yeah. Yeah. Yeah, so if you go back and yeah.
It's also available. I've got it all with that. My husband even more as you love me. See it. Yeah, right. So good. What happens? I see if you get into software. Well, still get- Yes. Know what it's doing. So I have these guys. It's gonna be one. Yes. Yes.
Did you get a break? I totally regret not taking those 3 days. Yeah. And then. And then someone going back to work, she probably, because the work just gets coming in.
Yeah, exactly. Have you met Nancy Blake?
Hey, in the yes, yes. I was saying about how tall I am in this lift. Because he's quite short, I feel very tall.
No, not problem.
That explains my weight.
Yes.
Oh, yes, exactly.
So it ended up being cancelled because something happened in the hospital overnight, so she had to cancel the meetings the next day.
Yeah.
It will be, because I'll make sure of that. It's when I'm realistic. It's like,
Yeah. But I think she may be moved. Make sure whoever does sort of, someone does come to like. Alan.
she's always on the so just like I'm just my brain is just
Constantly worrying.
I'm glad it's not just me. No, the other one's like yeah, that's exactly. We've got time. We've got time.
And it's taking one of these. Sorry.
Find people as well. So it's
Yeah, no, it's hard.
like 50. Oh, wow. Okay. That's great. That's great.
It's good way to have this hybrid option. All right. All right, we might make a start. Online people can hear us. Great. Excellent. All right, it's now my pleasure to introduce Pip Scrape from the Commissioner for the Victims of Crime. She's the Director of Strategic Policy, who's going to give a bit of perspective on protected comms and also provide a bit of background on some of what they've heard in their recent end-to-end review of the criminal justice process. Come on, Pip.
Afternoon, everyone. This is a very brief presentation. I don't have anywhere near the level of expertise of Nat and Liam in terms of the technicalities of the provisions. I'm certainly not a lawyer, but I suppose I just wanted to give an overview because not to say that these workshops are so important because of some of the things that we've heard and the level of confusion that's been around in terms of the protected communication regime. So really want to thank the Centre for putting on this workshop this afternoon and looking forward to some in the future. But I suppose from the Office of the Victim Commissioner for Victims of Crime perspective, I just wanted to note that there is a really large impact on victim survivors when confidentiality and victim privacy is not protected. So, and I think Liam also touched on this. So if the privacy of victim survivors is not protected, it can result in victim survivors feeling further violated and traumatized. They will lack trust in their counsellor or in the counselling process. And we know that they can feel a heightened sense of shame and guilt and disconnection from their community. And we also already know that sexual assault has a profound silencing effect on victim survivors. One of the, I think, things that is really disheartening in relation to sexual assault is the level of shame and guilt that victim survivors carry, and the fact that they just do not feel that they can disclose to so many of their own support network. We know that victim survivors will not often bring a support network to them to court hearings. They will travel in silence through the criminal justice process. And so one of their sole supports may be a therapeutic counsellor of some description. And so protecting that relationship is really of paramount importance, because it may be the only supportive relationship that they have in place as they navigate this process. And it also has shown that they may be less willing to report a sexual offence, or they may just disengage from the process when it becomes all too hard. So I think we've probably spoken to quite a few of you. We've spent the last few years working on a review of criminal justice responses to sexual offenders, focusing on victim survivor experiences. I know you've probably all been very patiently going, where on earth is the report from that process? It is finished. It's just going through its final stages at the moment. But we were really privileged to talk to so many of you through that process. In relation to protected communications, these are just some of the things that we heard. It's not all, but these are sort of the major themes. One is that there is no nationally consistent approach to managing counselling records in sexual offence criminal matters. And so there is a level of confusion from state to state. And we know that victim survivors move around. We know that counsellors move around. And so there is no nationally consistent approach, which is problematic. The legislation governing access to counselling records is different depending on the area of law. And we found that this came up with us time and time again. So it's different in family law, it's different in civil law, such as restraining orders, and it's different in criminal. And actually expecting service providers to navigate 3 different regimes is really difficult. And at a time when it's confusing and it's scary. So that's the complexity is confusing and challenging for some service providers, not all. And it can also take significant resources for service providers to challenge subpoenas and protect counselling records. So I think Liam was really right to highlight twice that you need legal advice. And certainly our office would advocate the same thing, that it's a really complex area of law and you should seek legal advice. But we also know that doesn't come cheap and it doesn't always come quickly. And so when you may have an order to produce within a short time frame and you sort of don't know where to go, and you may not even know where to go to seek that legal advice. You know, there are some practitioners that specialise in this area, but there are many that do not. So who would you even go to in the first place to seek that legal advice? And so I think some more communication around who some of those specialists might be and where you can go to seek that advice would be incredibly helpful. And I think one of the things that I wanted to touch on, although I know that this workshop this afternoon is for the service providers and for lawyers, I think as confusing as it is for service providers, just think it's even more confusing for victim survivors. They are coming into this process generally unaware that their counselling records may be used during investigations or legal proceedings. I think generally unaware is probably an understatement. I think most would have absolutely no idea that their records can be used in this way. And so you can imagine their distress when they actually discover that their counselling records can be disclosed or used during legal proceedings, or even the question is raised that their records can be used or disclosed during legal proceedings. So their one relationship of trust and support is about to be completely undermined by the legal process. We already know that the legal process can be incredibly re-traumatising for victim survivors. And so this obviously adds another layer of distress. So it's not about but I think we have to say that it's not about how do we mitigate that trauma. I don't think we can remove it completely. I don't think that the criminal justice process in some ways it is what it is, and we do have to work within that framework. There are some changes we can certainly make at a legislative and systemic level, but there are other changes that we can also make to support victim survivors through this process. And I know from our office's perspective, they're some of the things that we're just as interested in pursuing. So I suppose in that sense, what are some of the things that are important to consider? So the thing that we always come back to as an office is that victim survivors are entitled to agency and choice in all their decision making. And so do they have an actual choice? They may not always have a choice. I suppose one of the examples that we give is that if you talk about cross-examination, for example, a victim survivor may not have a choice about whether they are cross-examined or not, but they may have some agency and choice in their decision making in terms of how that cross-examination takes place. Do you want that to be in a remote witness room? Do you want that to be in court? Do you want a support person there? So I think it's about, okay, what agency and choice can we inject into this process for victim survivors to allow them the strength to make the decisions that best suit them? And so the first thing they actually really need is information. So victim survivors need effective information on the confidentiality of their counselling records presented in a way that they can understand. I think the legislative framework we've seen this afternoon, I thought Liam did an amazing job explaining it. It's still really complex. And I have been across this for a while, and I was learning stuff this afternoon. I was like, oh God, I would have no hope if I had not seen this before. And so how do we present this in a way that victim survivors understand at a time when they're probably not necessarily up to absorbing a lot of really complex information? And so one of the suggestions for that is that it's not a one and done process. So they need to have this information explained to them at each process where it may intersect with what's going on. So they may need this information at the very beginning of the process. And we also know that victim survivors may disclose a long time and receive therapeutic care for a long time before they actually report the offence to the police. And so there may be years of counselling records that are relevant. And so they report to police, and all of a sudden it might become subject to a subpoena or a record to produce. And they're like, what? And there might be 5 years, there might be 10 years worth of counselling records they need to consider. And so I suppose it's sort of, do victim survivors have this information at an earlier time so that when it's not a surprise for them? So it's maybe on a website, it may be in chats, it may be that we introduce a victim advocate model that victim survivors can speak to when they first start thinking about these things, and they can have this information explained to them. So yeah, I say victim survivors should receive this information early when engaging with therapeutic care or with legal processes. So I think if you're a service provider, it's really important that the confidentiality of counselling records is explained to victim survivors. I know, for example, the APS provide a lot of guidance to psychologists in terms of, these are the confidentiality of your records. These are the circumstances in which they may no longer be confidential. And I'm sure most service providers provide some guidance in relation to that, but just reiterating that it's really critical that victim survivors have access to that information early so they can make some decisions for themselves about what they choose to, even though it's important that they feel safe and comfortable to talk about their experience or whatever else they need to talk about, but they can make some decisions for themselves in terms of what they choose to disclose and in terms of what they choose to say. But it's also really important that victim survivors have access to independent legal advice as well. In the event that I say here, in the event that counselling records are subject to a subpoena or a request to produce, because it may be that they want to make submissions, and they obviously have rights and choices independent of service providers. They have rights and choices independent of the DPP. So it's really important that they have access to that independent advice that can help them make decisions for themselves or participate in a way that protects their agency. And so, but the independent legal advice might also come earlier. So it may be you're thinking of going to some therapeutic support services. You may be thinking of reporting the offence to the police. You may want to seek independent legal advice around what that might mean for some of your most sensitive information. And so it's really important that they have access to independent legal advice at that point as well. So they're just some of the few things that I think it's really important to consider. As I say, they're the more sort of practical things. I think it's fantastic that SOLSA have come on board. Up until, excuse me, up until SOLSA started, there was, apart from private practitioners and some community-based legal services that weren't actually funded to provide this service, victim survivors had no recourse to receive this advice. And so having SOLSA on the ground is an amazing step forward for us here in WA. I think we can go further. Legal Aid New South Wales, for example, has provided this service for a long, long time. It's unique in Australia, but we're hoping to see it roll out more. So we hope that there's more funding for this kind of service as well. And I think that's me, unless anyone has any questions. Oh yeah, sorry, I'm just.
Somehow putting this pressure on traumatized people. Because we need agency to block some of it. I feel like we put an objection. Because we're a big organisation, we're not. I feel a bit crushed. Sponsor, we're going to object. We lose the objection, we lose the objection, but at least we've taken responsibility as an organisation.
It does.
Sorry, can I just interrupt? Sorry, just for those online, they can't hear the question. So
yeah, so I was just about to, yeah, awesome, thanks, Hannah. I'm just going to repeat the question. It was in a few parts. It was, can, as a sector, produce an information sheet or some information, or come to a consolidated position on how to object to issues for summons and subpoenas. It's really important as service providers because they may have, I suppose, asking traumatised individuals such as victim survivors to object on their own behalf is asking a lot. And is it possible for service providers to do that in their stead? I would say to the first part, yes, I would encourage service providers to object, and I certainly wouldn't be expecting victim survivors to do it in the absence of service providers. I think it would be together, but victim survivors make their own submissions. They don't actually, they may choose to make their own submissions or not. Service providers may object on other grounds. So it's not a all or nothing. But yes, I agree. I think it would be really useful to have an information sheet. It's probably not something that our office would produce because we don't have the legal expertise. But I would suggest that if we worked with, say, SOLSA or the centre in terms of perhaps, and working with some of the service providers in terms of what information do you need, making sure that it will only ever be general in nature. Each case may need its own legal advice, but certainly if it's a jumping off point to give you some confidence about when you can object, how you should object, and also perhaps some links as to who might actually be able to provide that legal advice or who are some helpful sources of information. I certainly think that is something that Jessie.
It's something we've definitely given some thought to. Obviously, at the centre, we don't hold the legal expertise, so that's why we'd be looking, in terms of partnering with the right people. I think also for us, this kind of workshop was really a starting point to move towards some of that work, because I think we definitely see the value in having those kind of resources available to the sector and to victim survivors more broadly. So yes, in what form and what timeline, I could not say.
Thank you.
Thanks, Pip. I think that was a really useful grounding for us all just to have a think from a victim survivor point of view as well. All right, now we're moving on to case studies. So welcoming Olivia Tam from the Sexual Assault Legal Service to present on some case studies. To you.
Thank you. Hi, everyone. Now, just before I start with the case studies, I do just want to make a disclaimer. So they are only very loosely based on cases that SOLSWA has been involved with, and we have de-identified all the people involved in the case studies. So our first case study is about Sharon and Mark. Sharon and Mark have been in a long-term relationship for several years, and they shared 2 young children together. Sharon recently reported extensive and long-standing family and domestic violence to the police about Mark. Mark has been charged with multiple physical-related offences, including aggravated wounding and aggravated assault occasioning bodily harm. Notably, Mark has not been charged with any sexual offences. So these matters are before a jury trial in the Perth District Court. And separately, Sharon has experienced child sexual abuse in her youth from a family member, but this is not subject to any charges before the court. Now, there are 2 reports Defence Counsel seek to use in their cross-examination of Sharon, and I've included a couple of passages from them up here. Now, the first report is from a psychiatrist Sharon is seeing in relation to treatment for PTSD. In their report, they state Sharon has experienced both emotional and psychological harm from Mark. It does not mention anything related to Sharon's experience of child sexual abuse, and it does not say anything about Mark physically harming Sharon. Second report is from a counsellor. In their counsellor notes, Sharon has told this counsellor that she has been in a stable relationship with Mark for many years. It does allude to something happening to her when she was a child, but she does not elaborate on this. Now, it is likely Defence Counsel would seek to use these 2 reports to suggest Sharon has lied to the police about Mark physically assaulting her. They would want to put to her that she and Mark have actually been in a stable relationship for many years, because that is what she told the counsellor. So in legal terms, Defence Counsel would seek to use these documents as prior inconsistent statements to encourage the jury to question Sharon's credibility and reliability as a witness. That is, why would she tell the counsellor that she and Mark were in a stable relationship if that wasn't true? Now, I know to most people in this room and online, that kind of statement isn't unusual, especially when we understand the effects of trauma and the complexities, particularly when reporting family domestic violence. As we know, it is very common for victim survivors to minimise or even omit details about abuse, particularly when they are still in the relationship, they feel unsafe, or are experiencing loyalty, fear, shame, or even hope that the situation might improve. As we know, trauma can deeply affect memory, disclosure patterns, and the way a person talks about their experiences. So while Sharon's description to the counsellor may appear inconsistent when viewed narrowly, it is not unusual or unexpected outside of a legal context. However, this is a good example of the types of documents Defence Counsel may seek to rely on in criminal trials in order to challenge the evidence of a victim survivor. Now we move on to the question of whether Section 19C applies to these 2 documents. The first issue is whether Section 19C applies because Mark was not charged with any sexual offences. He was only charged with physical-related offences. So using the principles of statutory interpretation, the judge agreed with SOLSWA on this point, and they took a broad approach in interpreting Section 19C. So as such, in this particular matter, the judge said that Section 19C still applies even though the accused was not charged with any sexual offences. Now, the second question, was there a counselling communication? It was clear that Sharon spoke to both the psychiatrist and the counsellor in confidence. There was that traditional therapeutic relationship there. However, could it be said that Sharon received counselling in relation to her experience of child sexual abuse? In the first report, Sharon did not even mention this to the psychiatrist. She was primarily seeking treatment for PTSD. In the second report, Sharon does allude to experiencing some form of trauma when she was a child, but she does not specify what that was or even that it was of a sexual nature. Now, Salisbury's submission to the court was to look at the evidence in its entirety. Through the course of consultation with the state prosecutor, we became aware that there was actually evidence already before the court that Sharon had been raped as a child and that Mark had weaponized his knowledge of this to maintain control of her throughout their relationship. Now, on instructions from Sharon, Salisbury prepared an affidavit which confirmed that her PTSD related to her experience of child sexual abuse. Further, in this affidavit, Sharon swore that if her confidential counselling notes were to be used against her in this trial, she would never seek mental health support again. Now, this specifically goes to the public policy reasoning and objectives of the provisions and why they exist. In this case, the judge agreed with us again and took another broad interpretation of the provisions. So as a result, the reports were considered protected communications, and if defence wanted to proceed with using those two reports in their cross-examination of Sharon, they would need to make a separate application to do so. Ultimately, Defence Counsel decided to proceed with their case without using these two reports. So, without independent legal representation and someone to advocate on behalf of her interests, Sharon's voice may have been lost in a criminal justice system, which has honestly historically failed to centre the voice and needs of victims and survivors. Now move on to our second case study, which is about Claire and Terry. So Terry is Claire's biological father. Claire recently reported child sexual abuse that happened 15 years earlier by Terry. Terry has been charged with historical child sex offences and the matter is before the Perth District Court. Now, 10 years earlier, that is after the child sexual abuse occurred, Terry and Claire's mum are in the process of separating and are finalising parenting matters in the family court. As part of this, a family law consultant is appointed to make an assessment of the family, and this includes Claire. So Claire is 12 years old when she speaks with the family law consultant. In the family law consultant's report, she notes she asked Claire whether she had seen or experienced any sort of sexual stuff in the home. From the family law consultant's report, it is clear that Claire is guarded in her response, and the family law consultant notes her discomfort and her lack of eye contact when she eventually says no to this question. Now, it is anticipated that Defence Counsel would want this document to suggest Claire lied about her experience of child sexual abuse, because when she was given an opportunity to make a disclosure to the family law consultant, she did not. Separately, this is a good example of the potential intersection between family law and criminal law. So because the report was part of family law proceedings, Defence Counsel was required to make an additional application to the family court to take and then potentially use the document in the criminal trial. This application was granted in this case due to the prima facie relevance of the report to the criminal trial and the accused's ability to mount a vigorous defence to the charges. So now we come to the question of whether Section 19C applies. So, was the family law consultant providing Claire counselling in relation to the sexual harm she experienced as a child? I guess one of the reoccurring themes here is that protected communications can be a very complex area of law. And in this particular case, there were two clear and very sound arguments that could be made. So Solswer anticipated that defence counsel would say, no, Section 19C doesn't apply. If there was a lack of disclosure, which there was, how could the family law consultant be providing counselling for harm about an experience that they didn't even know existed? Further, because the report was ordered by the family court for the purposes of an assessment and not therapy, did Claire actually receive counselling from the family law consultant? Was her communication with the family law consultant made in confidence? On the contrary, however, Solswer would argue that even though there was no disclosure, the court should take a holistic view. The court should consider Claire's hesitation when being asked by the family law consultant about whether she had experienced anything sexual in the home. The court should also consider the charges before the court, that is, historical child sex offending. Furthermore, because family law consultants are typically social workers or psychologists, it would be normal practice for them to provide some form of counselling in accordance with the legal definition of counselling. That is, even if the family law consultant was only seeing Claire for the purposes of an assessment, they would have naturally provided some form of verbal or other support to Claire. Now, as part of the work we do at Solswer, we provide our clients with their legal options and we never tell them what to do. So when we met with Claire, we gave her our legal advice. We could argue that Section 19C applies and seek to exclude the document. We couldn't guarantee that that argument would succeed, but we explained the grounds we had to make it. Now, Claire had a copy of the report and was also advised by the state prosecutor about how they believe defence counsel may want to use the document. Claire understood the advice and she was able to clearly articulate why she hadn't disclosed her experience earlier to the family law consultant. So, Claire was 12 years old at the time, and that was the first time she had met the family law consultant. She knew she wasn't there to receive therapeutic support, but because the appointment had been mandated by the court. So all Claire knew at the time, when she was 12 years old, was that she was speaking to this person because her mum and her dad were separating. Now, I know this isn't rocket science, and most people in this room and online are very familiar with the typical timeframes it can take someone who has experienced child sexual abuse to talk about their experience. So years, decades, sometimes never. Now, Claire told us that she saw this report as just one piece of the puzzle, and she had prepared herself emotionally to give evidence about things that she described as much more horrific than this. So ultimately, Claire chose to sign a consent form allowing the documents to be used in the criminal trial. This meant that there was no need to bring a Section 19C application. Now, this case highlights the importance of informed consent. At Solswer, we prioritise the autonomy of victims and survivors. Our role is to empower them, not to shield or direct them, but to ensure they have the information, support, and agency to make decisions that are right for them. Now, in choosing these two case studies today, we deliberately selected ones that are very tricky and not straightforward. So, as we know, protected communications can be very, very complex. And even when the link between notes, documents, communications, and a client's experience of sexual violence may seem tenuous, there may still actually be room to make an argument. So in matters where protected communications is an issue, we want to ensure that victims and survivors have the opportunity to have someone in court advocating solely for their interests. As we all know, the criminal justice system can be incredibly disempowering. Criminal trials are often long, exhausting, and can leave victims and survivors feeling completely defeated. Now, if there is an opportunity for independent legal representation in a criminal trial, victims and survivors should be able to access it in a way that is trauma-informed, makes sense to them, and empowers them to have their voice meaningfully heard. And on this note, we do also recognise that there are many victims and survivors who never had the chance or may choose not to share their experience in a courtroom. Not everyone wants to report in a formal or legal way, and we fully respect and support that choice. At Solswell, we walk alongside our clients, allowing their voices to be elevated and heard in whichever way they choose. Those are our 2 case studies. Thank you.
Thank you, Olivia. Now we're just at open question time. So we have lots of time to take questions from the audience. Anna's online, so the floor is yours. Not for me though, I'm not going to answer any questions. The question was, is there anywhere in Australia doing this process particularly well? Sorry, Pip.
No. There are, I suppose, jurisdictions that are perhaps moving. So when WA introduced our provisions in 2004, they were actually quite groundbreaking. I think New South Wales was the first cab off the rank in 97, but WA wasn't actually that far behind in 2004. We've been overtaken a little bit. ACT certainly have updated their provisions recently and are really worth having a look at. But in Queensland, following the Women's Safety and Justice Task Force, are looking at amending their provisions as well. So it'll be really interesting to see where they go. So in terms of the legislative framework, there's probably, I would keep an eye on Queensland and the ACT at the moment to see where they go. In terms of practical support, I think Legal Aid New South Wales is the model to look at their sexual assault confidentiality provisions. They have had a dedicated service in this space for a long time. But it's also really interesting to see where the sexual assault legal service pilots go. So there's obviously one being provided in the ACT. ACT are moving towards independent representation in the courtroom. So that will be interesting. There's certainly no moves afoot to introduce that here at the moment. So that'll be interesting to see where that goes. And also they're extending the sexual assault legal service pilot into all states and territories. So it'll be interesting to see what sort of services develop out of that. So I know we should never pat ourselves on the back, but Australia actually has come quite far in relation to this. There is no confidentiality protection, for example, in the UK. And so our regime is by no means great, good, or even perfect, but we do have something which I think is a small win to celebrate.
So we're hearing workers and counsellors are not writing great notes because of concern over the information being used against the person. So how do you keep, have to hold 2 things to be true, recovery and that you're doing?
I'll just repeat the question for the online. It was a question about question/comment about how to balance the need to take good counselling notes with also taking less notes to protect client confidentiality. Casting the eyes around.
that will make it easier to respond. And we need to change systems, right? Because the point is supporting victim first and foremost. So how do we enable the organisations responding to have tools? Or at least at the best is responsive, because the victim ultimately is there for recovery, first. Systems change. And how would you ever get someone to agree? Like if we're talking about consent on an ongoing basis, you're constantly going to remind them that their notes are going to be used potentially against them. Find this really challenging.
Yeah.
So I want to know how people.
Yeah, absolutely.
Say I don't want to give in my face and say how. So I see what you're doing, but if I'm getting counsel and you told me my notes are going to be shared, wouldn't be disclosing.
So it's important to remember you don't have to write down everything the client tells you. So, it's you've got to think about what the purpose of the notes are, and then you've got to think about who might read them. So whenever we write any kind of therapeutic notes, we always know that those notes could be read by somebody else at any point in time, including the client themselves, who may ask to have access to them in the future. So they've always got to be written with that knowledge that they could be read by somebody else. And then you've just got, but without all of the
I think it's really important that we do sort of take a case by case approach to each of these, commons. One thing that I do want to highlight in the second case study I discussed was how important those comprehensive notes were. Sorry, I just wanted to add to what's already been said is that in the second case study I discussed, I just want to highlight the fact that that family law consultant made very comprehensive notes was actually very beneficial when the case came down to it. So, the prosecutor and also Claire, she was able to speak very clearly to her discomfort, her lack of eye contact, and that was really helpful. So again, I think it is important that it's sort of case by case. And, it's a complex area. It can be really scary, but I think it is also really important, like Nikki said, it's a fine balance. You need to make sure that you are writing notes that are sufficient for therapeutic purposes.
Around therapy notes that often I definitely lean on the space of not writing notes. Just because of that, and I will align myself with the client. But if you're writing notes from an objective or phenomenological observation point, then you're going to be saying things like observe the client not speaking, which would be thorough enough. It's important to stay with the client the whole way through.
So
Also, like kind of what OT was saying, sorry, Olivia was saying, that, and Nat can surely speak to this too, that sometimes in a criminal case, you having good records of a client's disclosure to you is actually make or break as to whether that case succeeds or even charges get laid. And so aligning with the client in that circumstance can actually mean making sure that you have a really good record of what they've actually disclosed for the purpose of a criminal investigation if that happens.
Yeah.
Taken together does good guidance. I think if you could go to that the perpetrator and write them with that guide,
I think as well, from a victim survivor side, from a policing one as well, is a lot of counsellors or psychs are early complaint witnesses, which is the only time hearsay rule is allowed in court. Is so your notes at that time is paramount for the victim survivor, how they have reacted, how he or she is reacting physically, mentally, emotionally. that's all evidence that can be led, and it's one of the only cases in which it can be led as hearsay. So from an investigator putting on my hat for the victim survivor, that's really paramount for us. And there are parameters to protect your notes. So there are legal ways in which you can protect your notes under 19C. So what I say is, and I understand, and it's an issue caused by police as well for the criminal side with order to producers, but I suppose have some confidence that the court should always be on the victim survivor side. Okay, sometimes we all know that it doesn't necessarily go that way. But if you're the first person that victim survivor is told, those notes for us are absolutely crucial. You can refer to those to give a statement. You don't need to produce them per se, but that is crucial for us, and that is an early complaint witness can be make or break for our case. So just from that side.
Survivor rather than necessarily the details around. I suppose mark progress or is using psych when a client comes into the service, symptomology of PTSD, etc., and then going through it. And then that symptomology which shows how counselling is aided in a mental survivor, but generally we have the disclosure and a comprehensive assessment.
Yeah, and I think that's sort of for us putting on my police hat for our victim survivor. That for us is big because not a lot of victim survivors tell a lot of people. And I mean, we have the Longman warning for a reason, and that will hopefully go with our new Evidence Act. But we have that Longman warning which tells a jury it's dangerous to convict when somebody hasn't been told or there's no, corroborative evidence. Okay. All for me, or can
Yeah.
I mean, family legal services, so I work predominantly. I'm just wanting to draw to attention the need for cultural consideration. I mean, and obviously that applies greatly to Aboriginal people, but it does for other people from cultural, linguistic, varied backgrounds. Aboriginal people are some of the lowest reporting people for these instances they don't like going to counsellors, they don't like reporting things, they don't like going to the police, they hate the court process, even if they've had terrible things. And I'm sure that's been your.
I used to be the RC of Halls Creek, so
Yeah.
and I've worked in Junjunjara and Nunandara lands. So yeah, I'm very
They do go to counselling. And the whole thing can be quite shameful. And I think when we're talking about protected communications, taking that into account, sort of saying, well, what was really going on here? This document, they're subpoenaing it because they're saying, it's relevant or whatever. You haven't admitted anything in this report, so there's an argument for inconsistency here. So, but what were they really saying? Very often they won't disclose things. And I think if people have got about what is being said in those communications, perhaps consult people who, another Aboriginal person or, somebody who's in the cultural norms for that particular.
And I think also their words. We tend to put a lot, and police, trust me, we use police speak all the time. We use words like decamp a vehicle. There's no such thing. You get out of a vehicle, you don't decamp one. So, we put everything into our own speak. And I think particularly with the Aboriginal community as well, is if you have an interpreter, you're losing so much more because normally the interpreter knows your victim survivor through the fact that they could speak their language. So, we've got Evidence Act that protects our victims, except in CALD communities and Indigenous communities, because it's such a small community. Our victim survivors are known to each other. So I think that hurdle is massive. And I do think when it comes to protecting those notes, that's probably more paramount. in regards to the fact that there is very limited, like we have the Safe to Say platform, to go off tangent, but that's for anonymous reporting. It doesn't work in remote communities. Where do they go to report in remote communities? So, you know, there are massive limitations. So 100%.
So many hands. All right, Megan. Oh, Monica, sorry. I was so close.
So we're about to send out a new broadcast, obviously. Oh, sorry. Sorry, my bad.
Sorry, the question was just about what are the internal police processes to make sure that the new broadcast kind of rules are being followed.
So the new broadcast will be sent out. It goes through our prosecuting services division, as everyone would imagine. Everyone has their own little sections that do it. So it goes through our prosecuting services division in consultation with the DPP. Most of the time, because it's got to do with the sexual assault survivor, it comes through to sex crime division if there's an issue. Like most of you would know, Detective Superintendent Hamish McKenzie, he tends to get a lot of the emails. If he's not there, I tend to get a lot of the emails. And then what I do is I address it. So one of the ones we had was from an area within our own. So I addressed it with the OIC. If it's from an outside station, I speak to the OICs and just say, look, just school your people a little bit on what it is. What I can say is order to produce doesn't come from a bad place. It comes from them probably not understanding but wanting to get as much evidence as possible to prove a sexual assault. So it's not done out of out of I don't care about what we're told. It's just done out of a little bit of ignorance because there's so much legislation that they're just not across all of it. So usually it comes to me.
I don't know. Better suited for Liam. Thanks, Nat. So the first one is, you know, I think for all of us, or me anyway, obvious when these communications might be beneficial for prosecution to use, as we covered primarily as a first complaint is the biggest example. Could you give some examples of in what circumstances defence would want to use it, but in circumstances where they would be able to prove that prima facie case? Like obviously if you know there's a prior inconsistent statement, but how often would defence actually know that there's a prior inconsistent statement? That's my first question. The second question is around client consent. Can you speak on the Act specifies that it has to be specific to protected comms, it has to be written. Can you speak a little bit to that? We've had some circumstances where councillors have done it just a basic authority to share information, and we've kind of gone back and explained, in our opinion, that isn't specific enough and how specific that has to be to actually meet the requirement.
Thanks.
Right. I'll just repeat the questions for the people online. The first one was about giving an example about when defence might want to use a protected communication and when they might be able to prove a prima facie case. And the second question was about client consent specific to protected communication and whether an authority to share is enough.
Yeah, both very good questions. And the first one as to how the defence might go about proving that where they haven't necessarily seen the document. It's interesting because the legislation, and I didn't go into that in the presentation, but the legislation tells us that in establishing a legitimate forensic purpose, there's certain things that won't cut it. And it sets out that asserting without proving that there might be a prior inconsistent statement is actually one thing where the courts, if that's all you're doing is just asserting without proving, that won't establish a legitimate forensic purpose. So the cases where it most commonly comes up is where the accused was somehow aware or privy to the document, and maybe they'd obtained it through some other means. So the case example Olivia used of where that accused was involved in family court proceedings, so was privy to that document through the family court, and so knew what was said to that independent consultant. And so that's how they knew that the contents of that report. But in other cases where they're just wanting to take a stab in the dark and hope that they made a prior inconsistent statement, in my view, that wouldn't be enough. They'd actually need to come up with something more convincing than that. There's also the ability of the court to examine these types of materials without the parties seeing the materials. And I didn't go into detail on this either, but the court could even examine the counsellor themselves. So the person ask them questions, again, without the involvement of the parties, and they could obtain the documents and look at the documents themselves. So there's some options there where even though the accused may not have seen the document, a court could examine the contents of the document. But there's certainly been cases where an accused has sort of just had a crack at asserting that there was a prior inconsistent statement there, but they don't have the evidence to support it, and they won't get past that first step of establishing prima facie legitimate forensic purpose. The consent question, because consent in the context of protected communications it's quite explicit. It's its own section in this series of provisions. So it's 19 capital H, which I'll just read out aloud. The protection provisions do not prevent a protected communication from being disclosed or being required to be disclosed in or in connection with any criminal proceedings if the complainant has consented to the disclosure. Consent is not effective for the purposes of this section unless it is given in writing and it is given expressly for the purposes of the protection provisions. So it's highly prescribed as to what sort of consent we're talking about there. And in my view, it would have to be a document that is plain as day, that they're aware of that it's protected. They are providing their consent, probably by reference to Section 19H of the Evidence Act. And I don't think any sort of general consent to disclosure would cut it, in my view.
So would it be enough that they say, I consent to this being given to police? Say, I consent to this as a protected communication being given for the purposes of, it has to show a level of, like you said, informed consent, that they know that protections exist first and foremost.
Yes, so because it has to be given expressly for the purposes of the protection provisions, and the DPP's office may have templates that, so there are templates that are a precedent form that the Office of the Director of Public Prosecutions use for the purpose of obtaining consent from a complainant. But yeah, my view is that if it was some other document where they've just generally said, I'm okay with people seeing this, that wouldn't be enough. It would have to be very clear that it was for the purposes of these protection provisions in the Evidence Act. Does that answer your question?
Yeah, that's great.
All right, thanks.
So I saw someone else's hand up before. Lisa?
The earlier behaviours before they escalate. And so conversation around convictions, we're kind of forgetting the preventative element of. So what are we doing to increase the, reporting of response to that? I'm quite interested as a community that works in this space, how, we can support women tell those. So they're
sisters who are at the other end, because the isolation from slavery is someone's reports. Yet many people expect. But sometimes you know from the police.
I will just repeat it for the online people in a very condensed way. But essentially, it was a kind of a question comment about the level of reporting being very low generally, but also at the lower ends of kind of extreme levels, severity of sexual violence, and how do we increase reporting at that early end of the sexual violence kind of spectrum, particularly for non-penetrative offences.
All right. I know I started to go off on the tangent before, but we've introduced an alternate reporting platform for every sexual assault, child abuse, whether it be physical, sexual, penetrative, or non-penetrative. So that Safe to Say platform gives us an anonymous reporting online for our victim survivors. We've had over 2,000 reports in that space since that came into inception on the 31st of July 2023. And it might not sound like a lot, but that's 2,000 reports we would never have known about in any other way. There was one case where basically a person reported on behalf of another victim and said, I'd never have reported to police because I don't trust you. And we ended up getting over 50 charges on that suspect. So I go, we're starting to take small steps. What I do is I always encourage people, no matter what the sexual offence is, make a report. Do we get it right all the time? No. No industry is ever going to get it right all the time. And you know, we can make mistakes just like anybody else. But the difference with the Safe to Say platform is I have a trained detective on the other end engaging with our victim. So the victim can ask questions, the victim can go, what happens next? The victim can go, I want to stay anonymous, but it was John Smith. Poor old John Smith, every time I talk, he gets more trouble. We keep intel. So if John Smith suddenly has 17 reports, we start going, what are we going to do about John Smith? So that gets to the preventative side to a degree. We're limited on what we can do, but it gives us really good intel for the anonymous. So we're in the process at the moment. It's about to be introduced into the teenage handout in schools. So for the teenagers and their parents to have access to they've got access now, but the QR code. And we're about to have our business cards finalised, which will go to SARC and any other area that want them, which will have the Safe to Say QR code and our investigative manual, which gives the rights for victim survivors. So people probably don't know our victim survivors have the right to ask for a male or female investigator. We tell them everything that's going to happen, what the court case is going to look like. So they're our proactive steps. And then what we also do is we currently do reviews of matters that have been finalised, and we have a panel review to make sure that we've done everything correctly. We've done all of our investigative actions, we've done the right thing and spoken to our victim survivor in a good, positive way so that they can try and continue the process. But ultimately, they have the power. At any stage they wish to stop, we stop until they're ready. So if right.
As well as the management of expectations. That as well along with the that's devastating.
It is.
Particularly if is this sort of thing. And so, my gut feeling is we need to do a lot of management of expectations. And so, with respect, expecting the perpetrators to this. They tend to, and then when they're not, it's devastating.
Yeah, so that question, and I'll try and see if I remember it all, was around managing expectations of the victim survivor, because a lot of investigations over an extensive period of time don't get to charges. So it's about also police managing expectations of our victims. I agree. We should be telling them from the outset what this process is about. We have a manual, not that we should read from a manual, but we have a manual for a reason. It talks of expectations. It talks of what could happen. And the words that I don't like are the words insufficient evidence, because what a victim survivor hears is I don't believe you. So that's, you know, that's a word we try and get our investigators not to use with our victim survivors to help manage that expectation. All insufficient evidence means is we believe them, we just don't have enough to get it to court. So there's nothing wrong with saying those words rather than there's insufficient evidence, because I can imagine the victim survivor on the other end going, so nobody believes me. You believe the offender, you don't believe me. So we're working very hard in that area to try and change our wordings, try and change how we talk, but managing expectations, 100%, we should be honest from the get-go.
There's one and one person talking about their friends, and you've got a whole cohort of people that go, oh, well, I'm not reporting that. It's not important.
I liken it to this. For the first time ever in the West, I saw the front page after Marabi got convicted. It was, this man is a rapist, we're going to put his face, we're showing his face. I've never seen that before on the West. Yet one bad experience, we lose every single person that's seen that that's ready to report, because our reporting comes from really good outcomes in court based on very strong victim survivors, you know, very brave people who come forward. That brings us more victim survivors because they have trust in us, and you lose that trust and we lose a lot of people. Let's go.
Right, last cast around the room.
I don't know if there's anything online.
No. Anna said none online. So with that, I want to thank you all, and particularly a big thank you to our speakers today. I think I speak on behalf of everyone that it's been extremely informative in terms of the level of detail for protected comms, and we all really appreciate your time. And thank you to everyone who's come. And I hope you have a wonderful afternoon. Thank you. Oh, and this, yes, and there's the Salsa event after this. Sorry. Thanks for the reminder. And for the people online, sorry about any technical issues today. Yeah, excellent.